Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers. If you intend to join us in our daily discussions, you are most welcome.
Uh, you see, if you have seen the Constitution of India, in various articles they use the term sex. You know, they have used the term sex, for example, and just I'm sharing this. Prohibition of discrimination on the ground of religion, race, sex, place of birth. State shall not discriminate against any citizen on the ground only of the following markers, in which sex is also one of the prohibited markers. So this cannot be a ground for denial of any facility or which is being allowed to other people. So access may not be denied solely on these considerations. These considerations plus some other considerations may be a ground for denial of the access or the facility. But these grounds standing alone, they cannot be a ground, and sex is one of them. And this ruling gives us a hint on, or gives us um, and what is the meaning of this word sex. So, and particularly in the context of trans men and trans women, you know, if you remember, the Supreme Court had given a ruling under the Special Marriage Act, that under the Special Marriage Act, whether people who are into into a relationship, into a live-in relationship, or whether people who are of the same sex, whether they can be allowed to marry. And the Supreme Court had said that this is not possible. They did not extend the right, they did not carry it so far. In that context, if you see this ruling as to what are the currents across the world, this debate is has come up in society, in a more or less a conservative society like India, which has been vastly untouched by such debates. This debate has also come to India in a way. So this ruling may be important for us as well, for determination of some issue arising in the future. So this article basically is about one of the important expressions in the Constitution, and which is frequently the ground for discrimination. For instance, I can recall the instance where there was a judgment of the apex court, wherein the apex court ruled that the air hostesses cannot be denied the duties, flight duties, merely after the first childbirth. That is not so. That would be a prohibited. That would be a discrimination on a prohibited marker of sex. That was the famous Aziz Barsa's case, in which the apex court held that denying air hostesses the duties of flight duties and putting them into ground duties only will be violative of Article 15 and other articles of the Constitution, equality in public employment, Article 16. So that was one of the judgments that turned around on the discrimination based on the prohibited marker of sex. So the Supreme the the international ruling which has come to us basically clarifies the expression, what is meant by the expression, what is meant by the expression sex um, in terms of transgender woman. Transgender means trans woman. Trans woman means beyond. Trans means beyond womanhood. So beyond woman will be basically a biological male, and trans man would basically a biological female. So trans means beyond. So what is the actual sex of these individuals? Then the court has held that the determination of sex of these individuals cannot be cultural. It has to be biological. So this is what, in essence, is the ruling, that cultural determination of the prohibited marker of sex is not to be taken into account, but we have to go by the biological marker. Now, this will have implications across the board in various instances. For example, there was a debate on one of the boxers. Unfortunately, I don't know his name. I don't remember her name. And she was supposed, there were allegations that she was a biological male, and but then she was allowed to compete in the females group, and there was virtually no competition on the ground. And the critics were very vocal about it, that the competition is not there because she was a biological male. So this kind of determination will definitely have its consequences in sporting bodies. It will have consequences in services, because now in services this kind of discrimination against the trans people is prohibited. But then what is their sex? What is whether they have the biological sex, or whether they have the cultural, whether you will go by the identity, gender identity, or you will go by the biological identity, is a question which may come up at any point in future. And this basically clarifies. And the court has imposed certain obligations on the government, that although you have to go by the uh, biological sense of the word when you when you interpret, and but in providing the facilities, you have to ensure that there is no denial of access to any kind of facilities that are there for the other people. Whatever facilities are there for others, they should be available to the trans people as well. So that kind of ruling has been there. And now we'll let us take up the questions under this. Um, 71st question you have already marked correct. I think there are no incorrect answers in this. Oh no, there is one. Yes, a UK-based 73rd question on your screen. UK-based company updates its workplace policies following the Supreme Court ruling. It designates single-sex toilets strictly for biological men and women. A transgender employee complains that they are being denied access to facilities matching their gender identity. Which of the following best describes the company's legal obligations? The company must allow transgender employees to use facilities matching their gender, what is this? Gender identity. Okay. So let us think aloud on this. What do you have to say on this? What do you have to say on choice A? Company must allow transgender employees to use facilities matching their gender identity. Is it like that? No, because it is gender identity, it is not sexual identity, right? Company must provide gender neutral facilities but can restrict single sex spaces. Is it like that? Facilities should become gender neutral but can restrict single sex spaces. Is it like that? What do you have to say? Yes. The company must remove all single sex facilities and make them accessible to all employees. So all single sex facilities should be done away with, and there should be no discrimination at all. Is it like that? Is this the purport of the ruling? Is this what the ruling intends to communicate? Yes or no? Third one, C. Say something, right, wrong, indifferent, whatever. Whatever. Hmm. Yes, somebody said something, but I did not catch what was it.
So, which option are you talking?
I'm talking about C. Question number 73, option C. Company must remove all single sex facilities. Is it like that? This is the purport of the ruling?
No, sir.
No. Gender must allow transgender employees to use single-sex facilities if they have a GRC. Is it like that? Gender recognition certificate. No, answer is no. Then please come to the 74. No, passage, next passage, 16. That was the only wrong question, otherwise, yes. Passage 16. Happens here is that dynamic transactions, uh, I gave a more granular example of what is a dynamic transaction. For example, I give somebody or X gives to Y 10 lakh rupees. Now, this 10 lakh rupees is to be given in a business transaction, in some commercial transaction. But actually, X gives to Y, X gives through a payment gateway, that is to say through a bank. He puts 10 lakh rupees in the account of Y. Now, Y was supposed to convey, say, vehicle to X. So this was the business transaction. However, the vehicle is not there. So the vehicle is not there. But the money has been circulated up to and given to another person. Given to another person, the Y. Money has been received. There is no vehicle in existence. There is nothing. The transaction does not exist. Simply X gives to Y rupees 10 lakhs. And it circulates it through a payment gateway. That is to say, the payment gateways are just like the way you are transferring money from one to another, just like UPI and all those. Those are payment gateways. So they circulate the money, and what Y does is he takes out the money, withdraws the money from his bank, or takes it out from his account, withdraws the entire money, and gives or returns the same money to X in cash. All right. So what has happened in the transaction? Money has flown out from the bank account of X to the bank account of Y. And it is shown to have flown out pursuant to a business decision to purchase a car. Y decides to purchase the car belonging to X and in return pays to X the sum of 10 lakhs. But actually the car is not there. The money has been transferred. Money has been transferred by Y to X. The money has been transferred by X to Y for purchase of Y's car, which is not in existence. So what does it do? You can show the car as a business expense, and that way you are lowering your profits. You lower your profits means what? You declare lower profits to the income tax. Once you declare lower profits to the income tax, your income tax liability comes down. So what are you doing? You are evading the tax. So this is what Benami transaction is about. Now the law says that the Benami transactions, Benamidar will not get anything. The property will remain with the beneficial owner. What does it mean? It means that if the Benamidars, it is not accounted for in the books of the Benamidar, if the Benamidar does not get the benefit of the transaction, then it means the liability of the income tax liability of the beneficial owner, which is the payer, the X in this case, who gets the car, a non-existent car, in lieu of payment for 10 lakhs, his liability stands. So the liability of the beneficial owner remains intact because the Benamidar's title is not recognized by the law. Is that all right? Does that give you a very granular view? That is very practical view of the situation. I hope you understand what is this Benami business all about. A tax evasion motion by which money is circulated in bogus financial or commercial transactions. That becomes a Benami conduct. Then Benami properties are there. You must have come and you must have many a times um, properties are registered in the names of close relatives, and those properties basically are held benami for somebody else. So those are benami transactions. For example, if somebody is very wealthy and he doesn't want to disclose so much of properties because involve properties in the name of names of his relatives. So those become benami transactions. In the 2016, the law was amended to say that the benamidar will get nothing, and the property may also be confiscated to the government. And the beneficial owner, that is the person who has put funds into the property and actually transferred the title or registered the title in the name of somebody else, that fellow will not get the benefit of income tax because he will be treated as the beneficial. He will be treated as the actual owner of the property. So this kind of then there are certain markers or yardsticks or norms which have been indicated for recognizing or identifying whether a property is a benami transaction or it is not a benami transaction. One of the markers which have been identified, or one of the this is what is the nature of use, what is the nature of possession. If the person who holds the property also holds it for himself and is actually using the property, then the transaction may not actually be a Benami transaction, and the Benamidar will get the actual title from the property. But if the Benamidar is not holding not holding the property, and the beneficial owner is also only holding the property, managing also, then it may be a Benami transaction, and the property will be considered to be one belonging to the transferor. That is the the person who actually pays for the property. 74. 74 is correct, so I'll not take it up. 75 is 50% correct, so I'll take it up. IT department issues a notice under section 23 of Benami Transactions Prohibition Act 1988 to a payment gateway company demanding details of transactions linked to certain UPI IDs. Company challenges the notice, arguing that there is no pending tax proceeding against them. Which of the following best describes the department's authority under 23? Notice is illegal, notice is without jurisdiction, within jurisdiction, notice is lawful but not renewable, the notice is bad in law and without jurisdiction. So, which do you think is the correct answer? Under section 23, they have the right to do inquiry also. The notice may not be a notice for prosecution, the notice may be a notice to join inquiry also. But all right. Straightforward question. This one. In 1990, a woman purchases a house in her husband's name, but continues to live and manage the property herself. 77 we are on. She retains the title deeds with herself it should be. Years later, her husband sells the house without her consent. She challenges the sale, decide whether the sale can be set aside. Sale can be set aside because the wife here is actually controlling the property, managing the property, living in the property, you know. So the Benamidar will be considered to be the real owner. Where is it written? Where is it written in the this thing? Which are the markers? Let me share the markers with you. The markers are here. Source of funds. That is 6 characteristics can be taken as a guide. Source from which the purchase money came, nature and the possession of properties after purchase. So that is also to be taken into consideration in arriving at a decision whether or not something is benami. Motive. All right. Position of the parties and relationship, if any. If they are close relations like husband and wife, then they will not call it benami because their interest is one. And custody of title deeds. So the wife is possessing custody of the title deeds, and surely conduct of the parties concerning dealing with the property after the sale. So after the transaction took place, how the property has been treated by which party. So many considerations will have to be taken into consideration to arrive at a finding whether or not something is a Benami property. Okay. Source, how you dealt with, nature of possession, nature of use, then motive, what was the motive, what is the relationship between the parties, and all these are that. And going by all this, if we arrive at I think I did not share that. I'm so sorry, I forgot to share where I was reading from. Anyway, the wife can successfully challenge the sale. Is this the correct answer? 77th question A. Is A the choice the correct answer and why? Yes, tell me, who will tell me? Usually it is Ryan who tells, others don't speak. Let someone else also speak. Is this the correct answer? And if so, why? Wife can challenge the sale successfully. Can she do that? Just now we have seen that the markers are the nature of possession, the relation between the parties, who is managing the property. You know, those are the markers. Those are after the sale transaction took place, how the property has been treated. All these are the markers. And since the wife is retaining the title deeds, wife is also purchases a house in her husband's name but continues to live in and she manages it, the property herself. Parties are in close relationship. And the husband sells it merely because it is in his name. So the wife will be considered to be the actual owner, beneficial owner of the property and not the husband. Come to the next one. This is also incorrect. Businessman buys a commercial property in his friend's name, but keeps the title deed in his own possession. The property remains in the control and possession of the businessman. Years later, the friend claims ownership. Can the friend claim ownership based on the sale deed? What do you have to say in this? How will you apply whether this property is Benami? Buys a commercial property in a friend's name, but the title deeds are kept by the businessman himself. So, and then control and possession of the businessman is there on the property. When the friend claims ownership, can the friend claim ownership based on the sale deed, which is there in his name? Yes, the friend may claim ownership. So this is one. This transaction takes place in 2024, and the earlier transaction had taken place in the year 1990. All right. This time the year of the transaction has undergone a change. It is after several years, and the amendment took place in 2016. All right. What was the amendment? This is the amendment. The amendment was this is the amendment. Parliament enacted the Benami transactions. Benami transactions came into force on November 1. All right. Came into force on November 1 under the amended law. A Benami, the person in whose name the property is held, is not considered the real owner if the transaction is proved to be Benami. Instead, the beneficial owner, the person who actually paid for the property, is recognized as the true owner. The amendment also allowed confiscation of Benami properties by the court. So this is the law. And these are the requirements. Benami transaction, you need to prove these 6 things. Source of funds, nature and possession of the properties, possession, motive, whether it is for tax evasion or for some other purpose. Position of the parties, whether they are in close relationship. Because people in close relationship frequently buy properties in each other's name. For example, husband buys property in the name of the wife. Because if you buy a property in the name of a woman, then the tax liability can be reduced. That way. Custom stamp duty liability can be reduced. The custom of the title deeds are for the sale. Who has custody of the title deeds? Conduct of the parties concerned dealing with the property after the sale. So these are the basic propositions which have to be applied. Applying these properties, can the friend claim ownership of the property, or ownership is with the businessman? After businessman is the real owner as he contributed funds for the purchase and retained control of person must do that he contributed financially to claim ownership. So which one do you think will be the correct answer? Yes, say something. Right, wrong, indifferent doesn't matter. But say something. Because when you say something, then I'm happy, very happy. If
So
you
B
don't,
is the correct
very sad.
answer.
That is B is the correct answer. You are correct because here there is a mistake, right? The reasoning seems to point to a mistake in this kind of thing. Either I have made the mistake or my steno has made the mistake. That kind of thing has happened. You are right. B is the correct answer. Now you tell me why
Because
B is the
it's
correct
here
answer.
written in Amendment 16, under the amendment law, Binamidar, the person is a whose name the property is held is not considered real owner if the transaction is proven to be Binami. The beneficial owner who actually paid for the property recognize the true owner.
Yes.
So
As per the propositions which are stated in the, and besides he has retained control. Besides the parties are not in close relationship with each. Besides the businessman has retained the custody of the title deeds also. So and the motive is also seems to be tax evasion the um, because it is a commercial property. So considering all these factors, this seems to be the correct answer. Right? It seems to be a mistake and remove this. Now we come to question number, yes, 78. I have to correct. I'll make a note of it, otherwise I'll forget. Just give me 1 minute. I'll check it up once again and correct it. And when I'll make a correction, your drafts will get automatically corrected. So no tension at all. Just give me 1 minute. Yes. Ah, oh, this brings us to a close. Now we can go to the next one. Please come to the next one. Yes, this is article passage 17, I guess. Passage 17. Limited power of courts to modify arbitral awards. Very nice ruling of the apex court. Please quickly go through it. Then we take it up. And if you go through it, you can straight away start speaking. It has certain important aspects. First of all, the passage is a ruling by a 5-judge constitution bench. So you have divisional benches, you have constitutional benches, 2 kinds of benches. Supreme Court always sits in divisional benches, 2 judges. Then you have full bench of 3 judges. Then you have constitutional bench of 5 judges. Then there may be a bench of 7 judges. Then there may be a bench of 9 judges. Then maybe a bench of 11 judges. The number of judges on the bench is always kept in the odd, so that you are not left with a situation where you don't have any award. When you don't have any award, or when you don't have any decision of the court, because suppose there are 4 judges, 2 on one side, 2 on the other side. So there is no enforceable judgment of the court. That creates a very problematic situation. So to avoid that kind of situation, you have constitution sitting, the Supreme Court sitting in benches of odd numbers. Of course, 2 is not an odd number. I appreciate that, but then that is how it is. 2 judges sit together. Then you have full bench, full bench or divisional bench, that is of 3, then 5, then 7, and then like that. Now that is number 1. Number 2 is that every judge is not bound to go with the other judges. He can write a dissenting opinion also. He can say that I don't agree with the judgment which has been given by my fellow brothers, and he'll have to indicate the reasons as to why he disagrees or he has to give a reason as to what is his opinion on the point. He doesn't have to say as to why he disagrees from the majority. That is not required. Once he says that these are his reasons and this is his decision, that's all right. Now it is for others to understand his judgment and give effect to it. He has given his judgment. So he is not, no judge of the Supreme Court is bound to follow the judgment given by another judge. They are all independent to give their own judgments. Sometimes it happens that 5 judges sitting on the bench give 5 different opinions, and it is not possible to find out what is the implementation of how do we implement what their lordships have stated. So it becomes a problem. This happened in one of the cases in K.C. Vasant Kumar, if I remember correctly. That was the Mandal Commission in the string of judgments that led eventually to the passing of the Mandal Commission judgment. I think in 1989, if I remember correctly. So that kind of thing, in that course of that judgment over the years, somewhere in the middle there was one judgment which was given by several judges, and each judge stated his own opinion, and it was very difficult to find out what is the judgment, what is the actual judgment of the court. Because the actual judgment of the court will be the majority judgment. Majority of the judges, what they are saying, that will be implemented. So that is how judicial proceedings, that is how they go. Now here, this is a constitution bench decision, and it has come from the three judges bench, the full bench. And the full bench, the procedure in such cases is that the full judge bench, if they think that the case is not properly laid out, if the case is not that the judgment is not proper, if the law is not proper, then they can refer it to the Chief Justice with their opinion as to why the law is not proper, what are their concerns with the law. And the Chief Justice will constitute a larger bench to hear the decision. That is how it operates on the procedural side, on the administrative side, I guess. So there is a reference, and the reference is marked to a superior number of judges, 5-judge constitutional bench, and they have declared the law. And the law is declared on a subject of arbitration, which is a very sensitive subject for all of us, because India has not picked up as a major international destination for arbitrations. It is other places which have picked up and which have become international hotspots for arbitration, particularly Singapore, right? So India is having this as a soft spot, that despite having a very advanced Arbitration and Conciliation Act of 1996, India has not picked up as a world destination for arbitration matters. That is a cause for concern. And this judgment basically alleviates a problem faced by the litigants. Because you see, once the arbitration is, first you have to move the court to appoint the arbitrator. Once the arbitrator has been appointed, or the parties themselves have appointed the arbitrator, then you have the enforcement of the award. If it is not enforced voluntarily by the parties, then there is a challenge. Then against the challenge, there can be an appeal. So, and against the appeal, there can be an SLP. So, it can be quite a complicated procedure with multiple layers to it. And it can be pretty expensive. And when the award, after so many layers, if the award is cancelled for a simple clerical mistake, or for a simple thing, typographical error, computational mistakes, then in that case, it becomes a real challenge for the litigators, for the parties, the conflicting sides, and that can become a real headache if they have to go through all the 4 stages once again. Means for the, suppose the appointment of arbitrator, nobody is questioning, all right, you go past that stage. Then you have, you move into appeal, then you move into SLP and all that. You do it twice for no mistake at all, for a very computational or clerical error. Then it becomes becomes a headache for the person. And if it becomes a headache, then arbitration is already not popular in the country. It would be prevented from being popular in the country. So that kind of these are basically the issues in this, and the law is modified now. Instead of completely undoing the arbitration and directing the arbitration to take place right from the scratch, the court can itself modify the award a little bit, and whatever is severable, means whatever can be detachable from rest of the award, that portion can be detached, and whatever is anomalous, that can be rectified, provided it does not go to the root of the award. Means it displaces the entire award and brings into existence a new award, that is not to be permitted. Nevertheless, non-consequential errors which are apparent can be taken care by the court, and to that extent the court can modify the award. 79 question. In case of Gayatri Balaswamy versus ISG Novasoft Technologies Limited, Gayatri Balaswamy was an employee of ISG Novasoft Technologies. She was terminated from her job abruptly. Now here 2 crore compensation was awarded. Now this unsatisfied with the quantum, she approached the Madras High Court. Madras High Court has awarded her significant damages of 1.6 crores over and above 2 crores. So you have enhanced the compensation to 3.6 crores. So 1.6 crores more. You won't call this a computational error, will you? Right? Then he says, however, the division bench of the High Court later reduced the extra amount to 50,000. They brought it down. Then the agreed petitioner approached the apex court for enhancement of the award amount. What would be a proper determination of dispute? Now the question is whether the amount which has been awarded can be detached. That is number one. Can be detached from the entire award. That is number one. Number second, whether it is an error which does not go to the root of the award, which does not go to the foundation of the award. The Supreme Court has agreed with the Higher Court has agreed with the High Court, and they have rejected the application on the ground of the basis of the law which has been laid out, that you can't create a new award by 3.6 crores, enhancing the compensation so much. So enhancing the compensation from 2 crores to 3.6 crores is not considered to be a computational or a typographical error. It is supposed to be an error which is undoes the award itself, right? So that is the reason why this has been decided in this way. So please come to question number 80. NHAI versus Hakim. The dispute involved compensation on land acquisition of National Highways Authority of India. The affected landowners challenged the low compensation rates, leading to arbitration proceedings. Arbitral tribunal ruled in favor of landowners but imposed an unusually high rate of post-award interest on the compensation amount. NHAI, dissatisfied with the huge interest rate, approached the court to seek modification, arguing that the tribunal did not provide a reasonable basis for setting such a high rate. Decide whether the petition may be allowed. So, what do you say? Petition may be allowed? The petition is allowed. Arbitral tribunal ruled in favor of the landowners but imposed an unusually high rate of post-award interest on the compensation award amount. Dissatisfied with the high interest rate, approached the court to seek modification. Tribunal did not provide a reasonable basis for setting such a high rate. So is this detachable from rest of the award? Is the question of quantum of compensation detachable from rest of the award? NHAI is not questioning the award. They are saying award, we are satisfied with the award. They are saying, but the compensation amount is not proper. So this is a petty matter, or this goes to the root of the award. What do you say? This goes to the root of the award, or this is something which is manageable through modification. And if the rate is lowered, then in that case, In that case, the award may not be undone. What do you have to say? It should be allowed means the party should be directed to once
The
again
party should be allowed to, since
means
the
the party
interest
should
rate
be
is high,
directed
it
to
can be
once
deemed
again.
harmful for the parties.
So petition can be allowed means what? Means the
The
parties
interest rate should be lowered a bit since it is
the
harmful
interest
for the
rate
other
should be
party.
lowered. Yes, it may be because this is detachable from rest of the award, right? So approach modification, see modification. So the modification may be allowed, right? Because this is detachable from rest of the portion. The award is not contested by the parties. The award they are saying award is all right. But what is not correct is the compensation which has been awarded because no reasonable basis for a high amount of compensation has been provided by the arbitrator. So modification will be allowed, right? Then you have 81. This is also incorrect. In McDermott International Inc. versus Burn Standard Company Limited, an American company, McDermott International McDermott International has entered into a contract with Burn Standard Company Limited, Indian company for supply of specialized industrial equipment. During the execution of the contract, a dispute arose regarding breach of warranty and non-compliance with technical specifications. The arbitral tribunal awarded damages on multiple claims, but the Indian company challenged the award, arguing that one particular claim was not pressed by either side, and yet the tribunal gave award on the same. Decide whether the petition may be permitted. So, what do you have to say? Petition may be permitted. Petition may be permitted with caveats. The court must refer the matter back to arbitration. Only one particular matter. What do you have to say? The modification may be allowed or may not be allowed. What do you have to say? Modification may be permitted or may not be permitted. Permitted because the severable portion is there. It can be isolated from rest of the portions of the award. Whatever is okay need not be undone. But whatever is not okay may be, the caveats. Petition may be permitted with the caveats means only the offending portions may be slightly modified. Maybe then substantially the award need not be interfered with. Then in that case the petition may be permitted, not permitted. That is the laws. Please come to this fingerprint disappearance and legal identification. This is passage 18. Okay, let us keep it for tomorrow. We'll be able to finish tomorrow. Please do the legal, logical reasoning part also. All right. See you tomorrow then. Bye-bye.
If you intend to join us in our daily discussions, you are most welcome.